Corey Lipschutz, and these are my co-counsel.
Good morning, Your Honor. My name is Jacob Hill.
Hello, Your Honor. My name is Meredith Clement.
Together we represent the plaintiff in today's case, Mr. Angel.
And is that Mr. Park behind you?
Yes, Your Honor.
Okay, so you do have a client in the court.
Yes, Your
All
Honor.
right, very good. Appearances for defense.
Yes, Your Honor. My name is Justina Ibuchevik, along with my co-counsel, Miranda Castro, as well as Emily Lindbach. We will be representing the defendant in today's case, Ms. Hayden Duran.
Duran, in the courtroom. All right, pre-trial matters plaintiff.
Yes, we have a few documents for the court's reference, specifically a copy of the stipulations agreed to by both parties, the statutes pertinent in this jurisdiction, available case law, a pretrial order ruled on by Judge Jackson, as well as the complaint filed by the plaintiff. May I so do so opposing counsel and approach the bench with them?
You may do that in that order, please. All right, good. So, all right, we'll both get at them. What else pre-trial for the plaintiff?
Your Honor, if I can draw your attention to those statutes, specifically on the bottom of the second page, you can see section 10.38. Are you there yet, Your Honor?
Got it.
Well, this section explains in the state of Midlands, we have a standard called vicarious liability. This case is about two minor girls, both 11 years old. However, suit is being brought against Ms. Hayden Duran, the parent of Jesse Duran, due to this vicarious liability standard. This means any actions committed by Jesse Duran while a child of Hayden Duran can be held liable.
All right, and I'm going to presume you're calling my attention to this in the way of a heads up. You're not asking you for any kind of a ruling, are you?
That's correct, Your Honor.
Very well.
And similarly on that note, below that, you can note section 10.56. Now, since parents of minors are held vicariously liable for their actions, and Hayden Duran is being brought suit against today, for purposes of hearsay in this jurisdiction, statements made by Jesse Duran are indeed considered statements by a party opponent.
Okay. Again, in the nature of the heads up, you're not asking for a ruling, correct?
That is correct, Your Honor.
Very well.
Additionally, at this time, the plaintiff invokes Rule 615, the constructive sequestration of witnesses except for party representatives. Mr. Park will remain in court today.
Okay, is there any issue with the invocation of the rule?
No issues, Your Honor.
All right, and you're going to intend to keep your rep in the courtroom too?
Yes, Your Honor.
Okay, here. Very well. Rules invoked, witnesses are constructively sequestered. Obviously, you're going to stay in the room, but we're going to pretend like you're not here, so be on your toes.
And with that, we're ready for trial, Your Honor.
All right. Pre-trial for defense.
Yes, Your Honor. The defense would like to tender a copy of the answer to the bench. May I proceed and tender?
And you can pass it across if you want. You can
don't
even
know.
toss it. I bet I can catch it. Ordinarily, I would not invite you to throw things at me. That's not normal courtroom decor. All right, we got two copies of the answer. Have you seen this?
Yes, Your Honor, prior to trial.
You're good with it? All right. What else for the defense?
The defense is ready to proceed at this time.
All right, we've talked a little bit about courtroom mechanics, and just to clarify, given the way we're set up, you folks do not need permission from the bench to approach opposing counsel. You may do so behind counsel table freely, but anytime anybody wants to come outside or around the counsel table, you need permission. You need to tell me why. We will grant permission liberally. We may have to reconfigure the well a little bit to let you do it, but I don't want to be surprised. Clear?
Yes, Your Honor.
Yes, Your Honor.
All right, so both sides have you announced ready for trial. That concludes pre-trial. Do we have an opening statement for the trial?
Yes, Your Honor. May I enter the well for opening statements, Your Honor?
You may do that. I would suggest you argue over in your witness chair,
Yes, Your Honor.
but you can move around if you want to. Just don't come sit on the bench.
Yes, Your Honor. May it please the court? It looked like a murder. On August 18, 2010, Sydney Park was found shot, killed in her living room of her own house by a single shot from an 80 Baker revolver. This is undisputed by both parties in today's case. However, in today's case, we expect to prove that Jesse Duran loaded that gun, Jesse Duran pulled that trigger, and that Jesse Duran shot and killed Sydney Park. Now, how could this happen? How could an 11-year-old child shoot another 11-year-old, Sydney Park? Well, in today's case, you'll hear the first thing on August 18, 2010 that Jesse Duran did is Googled on her cell phone how to load a revolver. Now, not long after that, Jesse Duran headed over to the Park House where Sydney Park, her friend, lived. On August 18, 2010, after they were left home alone in that household, Jesse Duran entered the combination to a safe, pulled out a revolver, and shortly later, shot Sydney Park. Now, in today's case, we have a burden. We need to prove to you by preponderance of evidence that Jesse Duran did indeed intentionally shoot Sydney Park. Now, you all might be wondering, why Hayden Duran, Jesse Duran's mother, is on trial today? Well, that's because in the state of Midlands, we have something called vicarious liability. That means if you're a parent or guardian of a minor child, and that child does something that's considered illegal, well, that child, you can be held liable for those actions. That means if we prove to you that Jesse Duran intentionally or knowingly shot that gun on August 18th, then Hayden Duran needs to be held liable as well. Now, to prove this to you, Your Honor, we're going to call off 3 witnesses. Now, first, you're going to hear from Andy Park, the father of Sydney Park. He's going to tell you how on August 18, 2010, he left Jesse Duran and Sydney Park home. Shortly later, he got a phone call from the Midlands Police Department telling him to come home. What he found was his daughter shot dead. I'll tell you, what he found looked like a murder. Now, next we're going to hear from Terry Chapin. Now, Terry Chapin is an eyewitness to the events that happened on August 18, 2010. She's going to tell you that on the morning of August 18th, she heard a gunshot fired. So she rushed over to the Park residence, she looked through the window, and she saw a gruesome scene that looked like a murder. And who did she see there? She saw Sydney Park dead, and Jesse Duran standing there, motionless, just feet from a revolver. Now, finally, we're going to call a forensic expert to the stand. You're going to hear from Jules Sebastian, the lead forensic investigator for this very county. And Jules Sebastian is going to tell you through a series of reconstructive forensic tests how she was able to conclude that Jesse Duran touched that revolver, Jesse Duran opened that safe, Jesse Duran extended her arm, and Jesse Duran fired that gun with her arm extended, pointed at Sydney Park. Now, at the end of today's trial, my co-counsel, Jacob Hill, he's going to come before you. He's going to ask you to review the facts and the evidence that you've heard today. The evidence is going to only point to one direction. The evidence is going to show what happened on August 18, 2010 looked like a murder. The person behind that gun was Jesse Duran. Find Hayden Duran liable.
Opening for defense.
Yes, sir. I'm going to ring here.
That'd be fine.
I'm just giving time to get a moment. May it please the court? Your honors, opposing counsel, and ladies and gentlemen of the jury, we are here today because of blurred lines. Before the day of August 18, 2010, we had 2 normal families that were best friends with each other. They lived next to each other for years. They even installed a gate in their backyard so that their children can play together regularly. Jesse and Sydney were best friends. They were all each other had in the world. On the day of August 18, 2010, tragedy struck. Tragedy not only struck the Park family, but also the Durans. Hayden Duran lost the people she relied on most, her best friends, Andy and Lee Park. Jesse Duran lost her best and only friend in the world, Sydney Park. She would never intentionally kill her best friend. Today, the plaintiff has the burden of proof. They have to prove to you by preponderance of the evidence 4 elements. You must find that all 4 elements are more likely than not. If you fail to find even one element less likely, their case in chief falls apart. The first element, that Hayden Duran had custody and control over Jesse. This is true. Although Hayden was not there on August 18, 2010, she did have custody of Jesse Duran. And she will come before you to attest to the fact that she did time and time again admonish Jesse and remind Jesse of the realities of firearms. The second, that Jesse committed an act of willful misconduct. We will prove to you today that there was absolutely no intent behind Jesse's action that day. Jesse will come before you and explain to you that her and Sydney were playing a game. Jesse will attest to the fact that she checked for bullets, found no bullets in the chamber, and then the game began. She ensured the safety of herself and Sydney. However, during that game, tragedy struck. The third, that the plaintiff's decedent suffered injury or death. This we do not contest, and we would sincerely offer our most heartfelt condolences to the Park family for the loss of such a beautiful life. However, the fourth element we will prove is less likely. The willful misconduct of Jesse was the direct and proximate cause of the harm suffered. This is not true. There was no foreseeability in the actions that day. Hayden could not have known that her life would change forever. Jesse did not know at the start of that game that she would lose her best and only friend. We will call before you Hayden and Jesse, who will attest to everything stated before. Also, we will call before you Dr. Ash DeRosa. Dr. DeRosa will explain to you that the likelihood of an accidental shooting increases astronomically when a weapon is kept in the home. Dr. DeRosa will also come before you and explain to you that there is comparative fault on the child, Sydney. Sydney knew about the weapon. Sydney knew the combination. Sydney accessed the weapon that day. She intentionally went to the safe, pulled out the gun for them to play with. This is a case of blurred lines. Jesse was playing a game that unfortunately ended tragically. Please do not lose 2 more people in this tragedy and find my client not liable for the intentional shooting of Sydney Park. Thank you.